and welcome to Hot Issues. This week, we are taking a look at the so-called Ayeni case. Hello and welcome back to Hot Issues, and as I indicated, we are looking at the so-called Ayeni case. We are looking at the decision of the High Court, and we would also have a look at the decision of the Supreme Court in this matter. What can we do to retrieve the money that the Supreme Court claims or says were illegally paid to Ayeni? What is all the hula baloo about the integrity of those who handled this case? And we are indeed particularly privileged to have with us in the studio the Deputy Minister of Justice and Attorney General, Dr. Dominic Ayeni. Sir, you're welcome to the studio.
Thank you very much. Thank you for having me.
What is the decision of the High Court? What is the essence of the decision of the High Court?
Basically, what the High Court decided was that on the basis of the evidence laid, both by the prosecution and by the accused person, that is Mr. Alfred Agbesi Ayeni, we the prosecution had failed to discharge the burden imposed on us under the evidentiary laws of this country to prove his guilt beyond reasonable doubt, and that is why he was acquitted and discharged. As you probably have heard, we have filed an appeal, and we disagree vehemently with the High Court. We think that we laid sufficient evidence to prove the guilt of Ayeni on the two counts of first causing financial loss to the state, and then secondly defrauding by false pretenses. So Kwesi, you realize, for instance, that first of all, the representation that he made that he had engaged in financial engineering and that there was an agreement was a false representation. It was false because we called as our prosecution witness number 2 Honorable Osafo Mafo, then Minister of Education and Sports, and he gave, in his evidence in chief, he gave evidence indicating quite clearly that there was no such agreement with the government of Ghana for him to engage in financial engineering on behalf of the Republic. We also called witnesses from the Ministry of Finance and the procurement unit of that ministry to show that at that point in time, no money flowed into the coffers of the government of Ghana as a result of what the accused person allegedly did. And so plainly, on the basis of the evidence, the representation that he had engaged in financial engineering on behalf of the government of Ghana was a false representation. And so it came as a big surprise to us when the judge said that we had not laid evidence to discharge the burden placed on us by the evidence decree, because we showed quite clearly from the plethora of evidence that we laid that there was no such contract, no such agreement, whether oral or written, between the government of Ghana at the time and Ayeni for any financial engineering. And but so
were
yes,
these material facts not available to the officials who decided that he should be paid 2% of the sum that he allegedly had engineered?
At the time that he made the representation, several meetings were held.
For example, the legal directorate at the Ministry of Finance, were they not in a position to know that no money is accrued to the government of Ghana and that there was no agreement?
They were in a position to know, and I'm sure they knew at the time that no money, flowed into the coffers of the government of Ghana at the time. But you see, it is not the behavior, you see, and this is the aspect of the case which I think through the judge's rendering of the decision, the impression was created that the conduct of these officials was material in proving the offenses with which Ayeni was charged. Of course, I cannot discount the fact that if they were available to give evidence truthfully in support of the state. It will help the case that we had brought to court. Okay, I'm not discounting that fact at all.
But they could also be asked to incriminate themselves, as it were.
Right. I mean, and they have a right under Article 19 of the Constitution not to self-incriminate. So they could invoke Article 19 of the Constitution and say that they will refuse to incriminate themselves. But of course, I mean, if you give evidence...
Or they could be hostile witnesses.
Right. That is also another reason why, at the point in time when we were making decisions about the witnesses to call, we took the view that we did not want to put these persons on the stand. The reason being that publicly they had made it very clear. Honorable Betty Mori Drusu, Honorable Batine Odro had made it very clear that they supported the case of Woyomi. So that meant that if we called them, you know, as you rightly pointed out, we then had to treat them as hostile witnesses. So the probative value of their evidence, you know, from the beginning would have been very, very low. Then we would have had to now cross-examine them. We'll call our own witnesses, and instead of leading them in evidence to prove our claim, we would now be simply cross-examining our own witnesses, and if they refuse to, talk, then the inference that the judge would draw is that you brought this witness to prove your claim. The witness turned out supporting the other side, and through cross-examination, you could not elicit sufficient evidence to be able to, disprove the claim that they were making. So it would have been much more difficult for us strategically to be able to put our case forward before the court if we had called them. In any case, I am sure Ghanaians are aware that on the 20th of April 2014, this same judge had said that the state had, made out a case and that Alfred Abwesewoyome should be called upon to answer. If you say you are calling the accused to answer, what does it mean? Because first of all, there must be a question to answer. There must be an issue for him to answer. And that issue cannot be, legally concrete unless we had laid sufficient evidence to prove that, he had engaged in that conduct. So as at 20th of April 2014, the state had proved the basic elements. That is the implication in law of calling an accused to answer, when the prosecution has concluded its case. As at the 20th of April 2014, the state had proven the basic elements of the two charges. That is, defrauding by false pretenses and then causing financial loss to the state. Okay. Now, interestingly, when Alfred Abwesewoyome opened his case, he called no witness. He was a sole witness at his own trial. And then, contrary to conventional judicial, practice of judging, the judge did not even say a word about his evidence. If you read the judgment, that 25-page judgment, it said nothing about what the defendant had said. In other words, the judge relied solely on the evidence that we had laid up until the 20th of April, which evidence, he said, had proven the basic elements of the case. So he relied solely on that, but turned around and said that our evidence was shoddy. Now,
so why then did he call upon the accused person to open his defense?
That is baffling. That is utterly baffling, because if you call upon the accused person to open his defense, you have admitted that the prosecution has done a sufficient job to prove the elements of the offense. So to turn around and say that the evidence of the prosecution was shoddy, was it based upon the shoddy evidence that you as the accused to answer? Because traditionally, if the evidence is shoddy, you throw it out and sustain the accused's application. That there should be the accused's submission of no case. But you don't call upon the accused to answer, then subsequently turn around and say that the prosecution had done such a bad job that the accused deserves to walk. In fact, the implication of calling him to answer is that if he does not show through reasonable probability that his story is true, he is going to jail. That is the implication in law. And in State and Amate and other decisions of the Superior Court, it's made abundantly clear that is the implication if the accused person is called upon to answer and his story is reasonably improbable. So we were shocked. And in your intro, you rightly asked the question, what is the impact or the implication of the Supreme Court decision?
We'll come to that.
Okay.
For now, one of the issues being raised simply has to do with why Woyomi was the only person on trial.
Yes.
Indeed, if the other state officials knew that his financial engineering had not resulted in the state getting any monies and so on,
yes,
then to some extent they were complicit in the matter. Why were they not on trial?
Okay. Let's go back to the Constitution. The constitutional role of the Attorney General is a dual role. In fact, as a principal legal advisor to government, the Attorney General advises, government on all legal matters, and then the Attorney General answers claims brought against the state in civil suits and then conducts prosecution. Now, the prosecutorial power of the Attorney General is highly discretionary, in the sense that the Attorney General has to carefully weigh his decision, taking account of a number of variables. For instance, the liberty of the citizen, the public interest, national security considerations, even, and I will say this advisedly, I don't want to be misjudged, for saying this, but even political considerations. That is why in the development of the history of the development of the common law,
I hope what you mean is not partisan political considerations.
Not at all.
But political considerations
bearing on the public interest, not whether the person belongs to one party or the other. The general good, right? If, for instance, the prosecution of one person, poses a danger to our democracy, it can imperil our democracy, we will probably decide that we do not want to prosecute that person, because maybe, for instance, the person is so popular, that there will be a popular uprising against the person's prosecution and so on and so forth. It has never happened in this country, but elsewhere, prosecutorial discretion has been exercised, to prevent political upheavals as a result. So I just want to explain that aspect of it. Now, the discretion of the Attorney General, whether or not to prosecute, is not an unfettered discretion, and at least that is my view. Article 296 of the Constitution is very clear that whenever discretionary power is vested in a public person, in a public office, that power must be exercised, in a candid manner, in a fair manner, and then also reasonably. So the decision whether we should prosecute someone cannot just be taken, willy-nilly. We need to be able to, justify it within the ambit of the principles of Article 296 of the Constitution. Now, when we came to office, when my boss was nominated and then confirmed, and sworn into office, in I think May of 2013. At that time, the previous Attorney General had considered with his team the possibility of a prosecution of these public officials that you had mentioned earlier.
Mm-hmm.
And then taking the decision with the team that he was not going to prosecute them. And in the case of Nekwe Tete, our chief state attorney, who was intimately involved with these things, and then Mr. Paul Asiminu, who was also arrested, the two of them were arrested together, decided to enter a nolle prosequi. In other words, he decided to tell the court he was not interested in prosecuting. When we came to office, we actually looked at the circumstances and reviewed the decision that was, and we examined the decision that was taken not to prosecute. We had debates with the bureaucrats, our prosecutors, as to the merits or demerits of not prosecuting or of putting these people on trial and so on. As I speak, there has been no definitive determination on that issue. We decided that we were going to go forward with Woyome because time was not on our side, going back and forth, because these things will also have to go into, the system all the way, to the president. But I must say that we have not sent any memo to the president on whether or not we are going to do the prosecution. So we have not yet, as I said, made a definitive decision, on that. And so I cannot on this program say whether or not we are going to, prosecute these public officials. But you see, time does not run against a crime.
So that is a principle. They may eventually be prosecuted.
They may eventually be prosecuted. That is what I can say for now. We may also decide that on the basis of all the things that we know, including but not limited to security briefings about their role and so on and so forth, we could decide that we are not going to put them on trial and leave that to posterity to judge. Yeah.
Now, what are your chances of succeeding with the appeal? Because some have said that the appeal is a waste of time.
Kwesi, it's surprising how even before these people read the judgment, okay, based upon journalistic accounts, some of them eminent jurists, respected eminent jurists, came to the conclusion that our appeal was dead on arrival. They did not read the judgment itself. They had not the benefit of reviewing the evidence, as I have done. Myself and my boss have been intimately involved in this process. We get briefings from the state attorneys when they return from court. We have the transcripts of the evidence in chief and the cross-examination and so on and so forth. So on a regular basis, we have been able to assess the chances, of our succeeding at even the High Court itself. In fact, we were fairly confident that we were going to win this case. So I was, kind of surprised that people judged our appeal with phrases such as dead on arrival. Look, let me tell you something. If you read the judgment, it is very clear that the judge was highly selective in the kind of evidence that he used. Okay, as I've said, he ignored all the evidence in chief that we led. He used cross-examination, statements that did not bear directly on the justifiability of the claim, and came to the conclusion that those statements justify the claim. I'll give you just one example. One of the directors of Waterville, one Olandi, was called to give evidence on our behalf. Now, we decided to call him because Waterville had said through their lawyers that Woyome was not entitled to any payment. Komitete, had written to say that Woyome was not entitled to any payment, and he had written on the instructions of Waterville. So we decided that we could tender the Komitete letter through the Waterville director, and we did. Now, Olandi was asked in cross-examination that isn't it true that Betimol Idrusu admitted that Woyome's claim was independent of the claim of Waterville? And his answer was yes. At the stakeholders meeting, Honorable Betimol Idrusu said that after all the discussions, she now understood that Woyome had a claim that was independent of Waterville's claim. Now, Kwesi, tell me, in God's name, how does this statement prove that Woyome was entitled to the money? That Olandi said that Woyome was entitled to the money. What he simply said, if Woyome was bringing a vacuous claim, it is a vacuous claim that is independent of the claim that we are bringing. Whether our claim is also legitimate is of of no consequence. What is important is that there were two separate fraudulent claims. Two separate fraudulent claims. That is what the evidence led by Olandi, and across the admission he made and the cross-examination. That is the only weight you can place on it. Yet this judge said that statement was an admission that Woyome had a justifiable claim. So there was so much selectivity in the evidence. And in conventional judicial reasoning, you take the evidence led in chief and the cross-examination evidence, and you ask yourself, was this person contradicting himself, under cross-examination? So you put the evidence led in chief on one side and the cross-examination evidence on the other, and then you draw a conclusion or an inference, and it will be the irresistible inference that you draw if you look at the pieces of evidence put together. It's like a jigsaw puzzle. You put the pieces together and you solve the puzzle, and that is what judges do. This judge did not do that. So for me, we have very strong chances, of overturning the judgment on appeal, and I would not want for to go into the merits of our appeal, in the sense because it's not proper. We've just filed a notice and so on and so forth. And of course the judges are also, they are members of our society. They watch your program. I would not want them to say that I prejudge what was coming to them and so on and so forth, but I can only say that having looked at the judgment, our chances, I'm confident that our chances, are very strong on appeal.
Hello and welcome back to Hot Issues, and today we are looking at the case of Wayome, the acquittal of Wayome by the High Court in Accra and its implications. And we are very, very fortunate to have with us Dr. Dominic Ayeni, who is the Deputy Minister of Justice and Attorney General. Now, various questions have been raised about the integrity of your office. For example, Mr. Wayome alleges that the Attorney General and Minister of Justice was a beneficiary of the monies that he took from the state, and therefore there's a conflict of interest situation. What is your reaction?
Kwesi, I will begin by saying that the integrity of the person of the Attorney General, that is Mrs. Briwa-Piopong, cannot be put in question. I will say on your program, and I'm not flattering her as my boss, but she is a woman of integrity. She has taken that office and worked so tirelessly with her team, including myself, to bring respectability to the office of the Attorney General, to restore respectability. Times were when MDAs would come chasing the Attorney General for legal opinions. Times were when state attorneys would not attend court and judges will complain. But today, you go to the courts and you find that our state attorneys are there. Why? Because she has put in place a monitoring mechanism. We have researchers monitoring and reporting and on whether the state attorneys are attending court. And when you don't attend court, we query you and ask you to explain why you were not in court. We have judges who are also members of the Legal Service Board and so on, and who also call us to tell us how the state attorneys are performing, and most of them are full of praise for the state attorneys. MDAs these days say the Attorney General's office works so hard that you don't need to chase after your letters, your opinion letters. You come and then within a few days you get a response from the Attorney General's office. So that is the kind of person we are talking about here. Now, as far as the allegations of lack of integrity, are concerned, I think that they are totally unfounded. They are totally unfounded because Wayome alleges, as you have rightly pointed out in his letter, that she benefited from the 51.2 million. Okay. When you have a law practice and you have a client who has instructed your partner to sue somebody who owes him, and remember, the suit was not, and there is a public record. You can go to the commercial court and find out whether the suit that was instituted by Mr. Tony later in anywhere alleged that the $1 million was a part of the $51.2 million that was paid by the state. Wayome owed Mr. Ray Smith, and this was an ordinary transaction. I don't know the details of how it arose. However, Tonilita then issued a writ of summons and a statement of claim against Woyome, and based upon the veracity of the claims made, Woyome capitulated and agreed to pay. Now, when you practice law, you know, for instance, that when you have sued on behalf of a client and payment is going to be made, usually the check will be made in the name of the law firm. You put it into your client's account, and then you issue you issue a check to your client in the amount that was paid. That was exactly what happened. So, wherein lies the benefit that the Attorney General, took? Was it in the legal fees that her firm must have charged? And there is no scintilla of evidence tracing that $1 million to the 51.2 million Ghana cedis that was paid to Woyome. So I think that these are just empty allegations meant to attack her integrity, because she is doing the right thing in chasing Woyome, first of all, to hold him criminally liable for defrauding the state, and then also for causing financial loss to the state if we don't retrieve the 51.2 million, and then also taking steps before the Supreme Court in order to retrieve the monies as ordered by the Supreme Court in the judgment in which Honorable Martin Amidu asked the Supreme Court for a declaration and for consequential orders directed at among others Woyome and Austro Invest and whatever, to pay all these monies back to the Republic of Ghana. So I do not think that there is any evidence that dents the integrity of the Attorney General when it comes to her role, in quotes, in the so-called retrieval of the $1 million from Woyome. She never went to court on behalf of her partner Tonilita. She never wrote any letter, signed any letter asking Woyome to pay the money, and so on and so forth. So for me, I think it's rather unfortunate that Woyome decided to attack her just because she spoiled his party by filing a notice of appeal. That is all that was done. As far as the former president is concerned, I listened to him. I don't think that he directly attacked the Attorney General's office.
No, he said the prosecution had been shoddy.
Well, I think he was quoting the judge. I believe, I trust the former president, and I believe that he was quoting the judge. He was basically parodying what the judge had said. And of course, he did not have the benefit of sitting through. That
thieves had been made to get away. He used the word in Ghana, July, and so on. He said all of those things.
You see, I heard that. It's unfortunate. If the reference to a thief was a reference to Woyome, at this point in time, the judge has said he's not guilty. All right. We will prove his guilt or otherwise on appeal.
No, it was not just about Woyome. It was also about persons who he claimed had surreptitiously gone and grabbed party positions to cover themselves.
I can imagine, that this is a reference to the Honorable Betty Mori Drusu. I don't want to sit in judgment over her. She's the predecessor or holder of the office, the reputable office of Attorney General of this Republic, and I will I'll decline, to make any comments that are adverse, to Honorable Betty Mori Drusu at this point in time.
But in your view, was the former president justified in making those claims that touch at the very integrity of the office of Attorney General?
Well, I think he was reacting to and riding on public sentiment, and the former president, very much in touch with the grassroots. The grassroots are not happy, and justifiably so, because whether we like it or not, this 51.2 million is the property of the good people of this country. And I can imagine, for instance, I'm a member of parliament for Bolgatanga East. And I was telling some of my foot soldiers that if we had that 51.2 million, we can transform what the whole of Bolgatanga is into, a modern paradise. We can do that. We'll build a lot of schools. We can do a lot of roads. We can transform the lives of the people. So it is a big loss to the people of this country. And I believe that is the reaction that, where the former president, is coming from. And I will not begrudge him, that. What I only say is that he should trust in the integrity of the current holders of the office. That the current holders of the office are doing exactly what he thinks, we should be doing. Chasing after whoever has taken the money, making sure that they are held criminally accountable, and making sure that the money, if not all of it, a greater part of it is retrieved for the people of this country to use for development projects. And that is what we are doing now.
What about claims made by Mr. Martin Amidu, the former Attorney General, also touching on the integrity of your office?
Well, look, it's unfortunate the Honorable Martin Amidu made those claims. Because as a lawyer, if he had followed the proceedings, if he had asked us to give him the transcript, of proceedings in court, he would have realized that we were not doing as bad a job as he was saying we were doing. I believe that the judge also took a cue from, Honorable Martin Amidu commands a lot of, respect within the legal fraternity and also, among citizens of this country. And I believe that the judge took a cue from what he was saying about our lack of commitment to prosecuting Woyome, and use that to get Woyome to work. That is the perverse outcome of the criticism that Honorable Martin Amidu has been leveling against our office. But the record is there, and if he wants to take, we can give him a copy of the record of proceedings, and if he can truly look at the record of proceedings and tell us that we did not lead evidence to show that Woyome defrauded the state. I don't know what to say. I'm sure he is a man of integrity, and that if we gave him the record, he would agree with us that we led evidence that showed that Woyome defrauded the Republic of Ghana.
Now there are two determinations, two conclusions.
Right. Yes.
One from the Supreme Court.
Yes.
Which says that the money needs to be refunded.
That is so.
And one from the High Court who says that Woyome is not criminally liable.
And that the payment was justified.
So where do we stand?
Well, if I were to give the two judgments to my first year law students, and remember I used to teach law for 13 years. I was a law lecturer. I would have been biased enough to tell them that I prefer the Supreme Court judgment. The reason is simply because the Supreme Court engaged in deep analysis of the constitutional basis of this payment and said that it was an unconstitutional payment. Okay? Article 11 of our Constitution is very, very clear in terms of the hierarchy of laws, that the Constitution is the supreme law, followed by statute, followed by subsidiary legislation and case law, and so on and so forth. The judge ought to have known that even though the Supreme Court said that its decision on the refunding of the money by Woyome was without prejudice to the outcome in the criminal trial, the Supreme Court made a definitive pronouncement on the legality of the payment and said the payment was illegal, which meant that the judgment of the commercial court, which basically the default judgment, which basically said that Woyome was entitled to judgment for the sum of 51.2 million with interest and so on and so forth, that judgment was null and void and of no effect.
But the Supreme Court said so explicitly.
Explicitly. It's not that we are drawing any necessary inference from it. The Supreme Court said it is null and void and of no effect. Now guess what? When Justice Ajat Nassam was delivering his decision, he found it convenient to refer to the judgment of the commercial court, a judgment that is a nullity, You see, Lord Denning said in McFoy and UAC that you cannot put something on nothing and expect it to stand. It will fall. So if the Supreme Court has said that this thing is a nullity, and you are just putting your justification on a nullity, do you expect it to stand? And by the fact that the Supreme Court was not dealing with a criminal matter but a civil matter doesn't mean that the doctrine of stare decisis does not apply in this case. That is the judicial precedent that you are bound by what the highest court of the land has said. He should have taken judicial notice of what the Supreme Court has said about the legality of the payment. So if the Supreme Court says the payment is illegal, in other words, in layman's language, it is an unjustified payment, and then you tell us that it is justified, what are you saying? You are contradicting the Supreme Court. Now, the good people of this country should know that what he has done has no impact on the orders of the Supreme Court. We still chase Woyome and collect the money on the basis of those orders, and we are doing so. We have served the hearing notice for the Supreme Court to give us directions, regarding how we retrieve the money. Because if you look at CI 16, which is the Supreme Court, rules, okay, they do not provide for how you enforce consequential orders of the Supreme Court pursuant to a declaratory judgment given in a constitutional matter. So the Attorney General is at a loss, as this is a novelty, so we are at a loss as to how we go about enforcing it, and we've gone to the court for direction. So the court will give us a day in court to come and then get the directions. Once we get the directions, you will see the swiftness with which we will run after him for the retrieval of the money.
But is the money available? Is the money sitting somewhere that you can lay your hands on?
Only Woyome can answer that question. But I can tell you our EOCO, Economic and Organized Crime, and the rest of them are sniffing around to find out, do the paper trail and find out where the money is. If there is no money, he has property. We'll go after the property.
Would that property be enough to compensate for nearly 52 million? No,
we haven't done evaluation. But publicly he claimed to be a wealthy man, but a wealthy businessman and a financier, of political parties. I won't name any political party that he has.
His name too.
Which one?
Oh, his name too.
No, because you should tell me if he has named two. Which ones has he named?
Well, you said political parties.
Okay. Of course. He said that. Or it is being said that he's a financier of my own party, the National Democratic Congress. I don't have evidence of that, but whether he finances the party or not is of no consequence. If we go after him and we find money in his account, we will seize it. If we find that he has property that can be realized in monetary terms to pay the money, we will seize it.
Have you found that he has property?
Oh yes, we know he has property, but we don't know the value of the property yet. But we do know he has property. We've laid hands on his properties. We know, his accounts. I can say on authority that the accounts do not have 51.2 million, Ghana cedis in them. The monies are not even. They are not much to write home about, but we are still doing the tracing. So at the end of the day, we should be able to retrieve something for the good people of this country.
Something?
Yes, we should be able to retrieve the 51.2. Okay, that is the target. However, if we are unable to retrieve 51.2 because first his accounts fall short of that amount, secondly, the properties he has, are not sufficient, to satisfy that amount and so on. We just cut our losses at that point in time, because what else can you do?
What else can you do?
Right. No, at that point in time, he would be a man of straw. Would have sold everything. In fact, if we have furniture in his house, we are entitled to sell the furniture. And just leave him with the basic things that he can live with.
Hello and welcome back to Hot Issues, and we are privileged to have with us in the studio the Deputy Minister of Justice and Attorney General, Dr. Dominic Ayeni, and we are discussing the Woyome palaver. And just before we went on break, I wanted to find out whether the decision of the High Court could in any way become obstructive as far as pursuing the decisions of the Supreme Court is concerned.
Right. First of all, we have to note, and I think I've underscored the point, that the Supreme Court decision was a decision in respect of constitutional reliefs. So it's a civil matter. The High Court decision is a decision in respect of whether and the extent to which Woyome was criminally liable, in defrauding by false pretenses and then also causing financial loss to the state. So it's a criminal matter. I do not think, and I don't see how the High Court decision can in any way impede the implementation or enforcement of the decision of the Supreme Court, because the Supreme Court has made it very clear that the payments were illegal, they were unconstitutional payments, and therefore that the state is entitled to retrieve the monies. Now, some people have thought that because in criminal jurisprudence, a higher burden of proof is required of the state, and because the judge has said that the state has not discharged that burden, then it means that it sweeps, it encompasses the civil aspect also, and that he's walking away from the criminal, from jail, and also walking away with the 51.2 million, partly because the judge also said in his judgment that the payment was justified. I think that is what is making it, is kind of implanting, some thinking in the minds of people that, because he's been discharged, acquitted and discharged, then we cannot go after him, to enforce the Supreme Court, ruling. But that is not true. The criminal judgment will not in any way stand in the way of our enforcement of the Supreme Court decision. In fact, it cannot even be prayed in aid of Woyome when we are before the Supreme Court, because the Supreme Court is the highest court of the land, and you cannot ask it to be bound by a decision of the High Court, even though it is in a criminal matter. So yes, there will be no impediments. We will pursue Woyome, dual track approach, as I've said, to hold him criminally accountable before the Court of Appeal, and then Ghanaians must know that if the Court of Appeal agrees with us, that is with the prosecution, it will mean that the High Court decision is overturned, and the Court of Appeal will then convict him and then impose the sentence that the law requires, that he should go in for, a minimum of 5 years in jail for at least defrauding by false pretenses. He can go in for a minimum of 5 years up to a maximum of 10.
Now, some have said that this case demonstrates quite clearly the need to decouple the office of the Minister of Justice from the Attorney General, and that perhaps it is time for us to get an independent prosecutor. What do you think about this? Okay,
let me start from the suggestion that we get an independent prosecutor. I think that the office of an independent prosecutor is a great idea. It is a great idea in the sense that usually when you have the office of an independent prosecutor, it is politically detached. You have a group of professional prosecutors and investigators under the same roof who pursue criminal matters irrespective of the political coloration of the criminal and so on and so forth. So I think it's a very good idea. As to whether we should decouple the Minister of Justice and Attorney General's department, that is a political decision as against a legal technical decision. People tend to think that the Constitution creates the office of Attorney General and Minister of Justice. The Constitution does not. If you read Article 88 of the Constitution, it's very, very clear. It doesn't create two offices. It says there shall be an Attorney General of the Republic of Ghana who shall be a Minister of State and the principal legal advisor to government. Where is the Minister of Justice here? There's no Minister of Justice. The Constitution is basically according the Attorney General a ministerial status so that the Attorney General can have audience in cabinet. That is all.
So you can actually have an Attorney General who is also a minister and a Minister of Justice.
Yes.
And it would not be
There will be no conflict. So politically, if His Excellency John Dramani Mahama decides today that he's creating a Minister of Justice, and he's assigning that ministry with the justice sector specifically defined, all right, and leaving the Attorney General to do just the professional work of being the government's lawyer, the government's, running the government's chambers, there will be no unconstitutional, act being committed by him. But somehow or another, I think people tend to read the constitutional provision as creating a fusion of the Minister of Justice and then the Attorney General's office. For me, I think if it is detached, it will not take away the politics in the office of the Attorney General. Practically it will not, because as the government's principal legal advisor, the Attorney General will still have to take account of political considerations. The Attorney General will be sitting in cabinet with other cabinet ministers and dealing with political matters, okay, and advising them as to whether or not what they are doing is in compliance with the constitution and the laws of this country. So it will not all of a sudden take the politics out of the job of the Attorney General. It will probably make it possible for the Attorney General to focus more on the dry legal matters than the policy aspects, which is what the Minister of Justice does.
Is it true that the legal firm of the current Attorney General, private legal firm of the current Attorney General,
right,
in any way represented Wyoming, or an interest that could be coupled with the interest of Wyoming in a lawsuit?
No, not at all. I'm very much aware that has never happened. In fact, on all occasions, the firm has always sued Wyoming. In other words, they've always been on the other side, of suits or of matters, legal matters brought, against Wyoming. They've never represented any interest that coincides with the interests of Wyoming. Look, I have not dug into Austro Invest and the shareholderships and the directors and so on. All right, but the firm sued Wyoming on behalf of Ray Smith, who is a director of Austro Invest. Now, if Wyoming is a director of Austro Invest, the suit was not on behalf of Austro Invest. It was actually on behalf of Ray Smith, an individual, against Wyoming. And I don't see how that creates a situation of conflict of interest for my boss.
Now, going forward, what do you propose we do with judgment debts in order to avoid the kind of situation we find ourselves in today? As Deputy Attorney General, how may we handle judgment debts so that we don't get into this quagmire?
Well, we have done a number of things. I can only give examples of the things that we've done. In the past, when judgment debts came before for instance now, if there is a default judgment against the Republic, we call the state attorney and say, tell us why this default judgment should stand. File a defense. And my boss will write there, file a defense within 1 week. Okay, most of the time it's the MDAs that give us the problems. They won't give us the material necessary to file a defense. I have had those situations before when I've had to write to ministries and departments and instruct that information be given to us so that we file a defense on behalf of the Republic. You see, there's this notion out there, and it sickens me when I encounter that the state's money and its property doesn't belong to anyone. That is a falsehood. That it is utter falsehood. The state's money and its property belongs to you and I as citizens of this country. It's common property. So people don't really care when it is a judgment against the state. But these days we don't take default judgments lying down. So that is one thing that we are doing. I will give you an example of a judgment, and then when we see a judgment against the Republic, and my boss is better than me in this one. When she sees the amount, she will immediately cause an investigation to be done. Okay, There's one that came to us recently for 350 million Ghana cedis, judgment debt from Kumasi. Okay? The judge had rendered his decision, it looked watertight and so on and so forth. But she said, let's investigate this matter. Because see, as we speak, we paid PricewaterhouseCoopers to do an audit. Okay? The people are now ready to accept 94,000 Ghana cedis payment. Because see, I'm telling you this, I can give you the file. If you want, I can give you the file and everything. They are now ready to accept 94,000 Ghana cedis.
Instead of
350 million. The file is there for the people of this country to see. And my boss went to court herself in Kumasi. She wouldn't even allow me to go.
Anyway, so thanks very much.
My pleasure. My pleasure. Studio. Thanks for having me.
Yes.
Thanks.
We have been in conversation with Dr. Dominic Ayeni, who is the Deputy Minister of Justice and Attorney General, and we've been talking about the Wyoming case. We do hope that we've managed to bring some clarity to the issues. And please don't forget, we give you the best of everything on this channel, TV3.